Hello, my name is Marc Atas. I'm an attorney licensed to practice law in the state of Maryland. I've been practicing law since 1980, approximately 37 years. My areas of specialty are personal injury, auto accidents, and workers' compensation. The purposes of today's video is to discuss the taking of a deposition. First, start out by what, in fact, is a deposition. A deposition is usually taken in the office of one of the lawyers or at the office of a court reporter. The purpose of the deposition is for the other side to find out what the different witnesses are going to say in court. The rules of discovery and the rules of evidence that apply to lawyers say that everyone is entitled to know before we go to court what each one of the witnesses is going to say, and that there's not going to be any surprises. It's not like the old times on Perry Mason where the surprise witness comes up and stands up and then says whatever they have to say. But the way court is today, the courts want to encourage cases to settle or to be resolved, and because of that, they want everyone to be aware of what's going to be said in advance. So that's the purpose of the deposition. When you are a person who's making a claim in an auto accident, more than likely, at least if your case is tried in the circuit court, your deposition is going to be taken. At that deposition, you will appear along with your attorney. Prior to the deposition, you will probably prepare for the deposition, and the information that we're going to go over now is what you would be preparing with, and then if your lawyer has done a good job preparing you for the deposition, the same questions most likely will be asked at the deposition that were asked when you prepared for the deposition. At the deposition, in addition to you appearing, you will be there with your lawyer, and the other lawyer will be there. There will also be a court reporter there. Unlike a recorded statement, this particular statement is going to be under oath. The oath is going to be administered by the court reporter, and then anything you say in that deposition is assumed to be the truth under the penalties of perjury. Once you say something in a deposition, you're kind of going to be stuck with it. So you want to make sure you give the right answers, and that's the purpose of preparing in advance. At the deposition, your lawyer will be able to object to questions, but ultimately you're still going to have to answer them because there's no judge there to rule on the objections or the admissibility of the evidence. So at this point, since it's a discovery deposition to try and figure out what you're going to say, even if the other side objects, more often than not, you're going to have to answer it, unless the question is totally off base, at which point your lawyer may instruct you not to answer it. But unless your lawyer instructs you not to answer it, you're still going to have to answer the question, even though there is an objection. Why are the depositions taken? The main reason why the depositions are taken is so that the other lawyer can find out as much information as he possibly can about you and about your case. In addition, it may supply some additional avenues for the other lawyer in order to verify your story or to follow up on leads that the lawyer may want to use in order to figure out what's really going on in your case. The other purpose of the deposition is to get to know you, to determine what kind of witness you're going to make. So, if you go to a deposition and you do a good job, then the other lawyer is going to leave with the impression and report back to the insurance company that you did a good job, that you're a person that a jury is going to like or a judge is going to like, and it may make it more likely that your case is going to settle. If you do a poor job at a deposition, then the insurance company lawyer is going to go back to his insurance company and tell them you make a poor witness and that this is the kind of case that we should try because no jury is going to have any sympathy for you. So it's extremely important what kind of impression you make at the deposition. When you go to the deposition, you should dress appropriately, just like you are going to court most likely, because that's all part of your appearance. If you come in a t-shirt and jeans or a t-shirt and shorts, you're not going to make the same impression if you come in and dress well. So for that reason, I always tell clients to dress up for the deposition, just like you're going to court. At the deposition, the questions will be asked by the person who scheduled the deposition. So if you're the plaintiff or the person that was injured in the accident and the insurance company lawyer has scheduled your deposition, then you're going to be the first person that testifies. He's going to be asking you a series of questions, and that's part of the purpose of this video, is to go over what those questions might likely be. They are allowed to basically ask you about anything that's going on in your life from basically birth until the date of the deposition. The purpose of the deposition is to try and discover information that would be relevant. However, they may ask you a bunch of irrelevant questions that may lead to relevant information. Even though the questions seem irrelevant to you, they may seem relevant to the lawyers, or they may lead to relevant information. And that's why the scope of what they can ask is really relatively broad. Deposition will typically start off with the lawyer explaining to you that anything you say is going to be typed by the court reporter, and that it can be used later in court, that if you need to take a break, you need to let him know. If you don't understand what he's asking, you should tell him you don't understand it instead of trying to figure out what he might be asking you. I always tell clients, if you don't understand the question, don't say anything other than, I'm sorry, I don't understand the question. Could you rephrase it, or could you repeat it? If you still don't understand the question, tell him that again until you actually understand the question. If you need to take a break, you tell him you need to take a break. If you're uncomfortable or tired and you need to get up and walk, whatever it is, you should do that, because during the deposition, once you say something and it's written down, that's going to be used against you later in court. Once the deposition starts, it usually starts with some general background information. Your name, your address. They could ask you every address you've ever lived at. They could ask you your educational background, every college you ever went to, every high school you ever went to, any grade school you ever went to. They can ask you what courses you took in college. They can ask you about your work history. And then they may ask you about every job you ever did, what you did at every job, when you worked there, who your supervisor was. After they get through, they're going to ask you whether you're married or single. They're going to ask you if you have any children. If part of your lawsuit involves how it's affected your marriage, they're going to ask you a lot of personal questions about your marriage. How long you've been married. They may even ask you questions about your sexual relationship with your wife, the things that you do with your wife. They can ask all kinds of questions related to your marriage if that's part of your suit. After they get through this preliminary information, they're going to go through what happened in the accident. So they are going to go from A to Z, starting from when you woke up in the morning to when you went to bed that particular day. They're going to ask you what you did, whether you had anything to drink, whether you took any drugs. They're going to also, and we'll get to this later, ask you about your history about drinking or drugs. They're going to ask you what you did that morning. They're going to ask who you met with, who you spent time with, who you saw along your way. You're going to need the people's names, addresses, and phone numbers, because they're going to try and verify all this information. If this is a car accident, they're going to ask when you left from wherever you left. So if you left from your house, what time you left, where you were coming from, where you were going. They're going to ask you what route you took. So you're going to need to know the names of the roads. They're going to ask you how long it took. They're going to ask you how fast you were going. They're going to ask you whether you were driving or a passenger. They're going to ask you whoever else was in the vehicle with you. They're going to ask you what kind of car you were in. They're going to ask you the age of the car. They're going to ask you whether there were any defects in the car. Then they're going to ask you what route you took. Then you're going to describe the route you took. They're going to ask you about the lights or traffic control devices. They're going to ask you about the lanes. They're going to ask you whether it's one-way or two-way. They're going to ask you what direction you were going. They're going to ask you what direction the other cars were going. They're going to ask you about what the weather was like. They're going to ask you about where the sun was. They're going to ask you what the road conditions were. At some point, they're going to ask you how the accident happened. After you get through all this detail, then they're going to have you break it down more slowly, exactly what took place immediately before, during, and after the accident. They're going to ask you about the other vehicle involved in the accident. They're going to ask you to describe the color. They're going to ask you to describe the direction it was coming from, how fast the vehicle was going. They're going to ask you to describe the driver of the other vehicle. They may ask you what the name of the other driver was. And then basically, how fast was that car going? What direction was it going? Just so that they can lock down what happened. They're going to ask you how the intersection works. Is there lights? Is there stop signs? They're going to ask you the sequence of the lights. They're going to get into if you were observing a red light, what color, when was the light red, when did it change, where was your car located when the light was red, where was your car when you were located that the light was green. They're going to ask you about what's in the block. Is there cars that are parked on each side? Is there houses? Is it a retail area? Then they're going to get into what happened to you inside the vehicle. Did you move forward? Did you move backwards? Did you move sideways? After that, they're going to ask you what happened immediately after the accident. Did you call the police? Did you call your mother? Who did you call? Who did you speak to at the scene? Did you talk to the other driver? Did you talk to the passengers in your car? Did you talk to any witnesses? Did you get the names of the witnesses? Did you get their address? Did you get their phone number? What did the witnesses look like? Where did the witnesses come from? Where were the witnesses at the time of the accident? They're going to ask you what happened after the accident. Did you receive any medical treatment? Did you go by ambulance? Did you go to the hospital? Did you follow up with a doctor? What complaints did you have at the accident scene? Who did you complain to? Did you tell the police officer you're injured? Did you tell the other party you were injured? Then they're going to ask you, what did you feel like at the accident? And you tell them what body parts, and they're going to ask you specifically what problems were you having with each body part. Then after that, they're going to get into your actual medical treatment. And they'll ask you about what doctors you saw, where they were located, what were the names of the doctors. If you got physical therapy, where was the physical therapy done? What was the name of the therapist? How long was the therapy visits? How long was the doctor visits? What did they do for you at therapy? What procedures did you have at the therapist? What procedures did you have at the doctor's office? How many times did you go to the doctor? How many times did you go to therapy? What period of time did your treatment last? What other specialists did you see? What was their name of the specialist? Where were they located? What was their phone number? How did the accident affect your ability to work? Where were you working at the time of the accident? What type of work do you do? How long have you worked there? What is the address of your employer? What is the name of your supervisor? What is your phone number at work? How long have you worked there? Were you able to do the work you were doing at the time of the accident? If not, what is it about that job that you couldn't do? Why couldn't you do it? When did you return to work? How much money did you lose as a result of the accident? How much are you paid? Are you paid weekly or by the hour? Are there any benefits that you lost? If you were not able to return back to that type of work, were you able to find another job? If so, where? How much money did you make? Did you lose any money as a result of having to take a new job? If not, where did you look for work? When did you look for work? Who did you contact? Did you create a log for that? If so, provide the log. What were the results of that effort? In addition, they're going to ask you, how did this affect your daily activities? So you have to be prepared to tell them, if you're a mother or father, how it affected your activities with your children, how it affected your activities with your spouse, how it affected your ability to do your work around the house, how it affected your extracurricular activities. You need to do a good job of explaining what it is about those injuries that prevented you from doing what you normally do. They are going to ask you about your medical history, basically from birth until the date of the accident. So you're going to need to know the names of every doctor you've ever seen, their address, their phone number, what they saw you for, what medical conditions you have, who treated you for those medical conditions. They're going to ask you about prior injuries you had. That's going to include prior accidents, and they ask you, what part of your body did you injure? What doctors did you see for those prior accidents? What other history do you have of other treatment involving those particular cases? They're going to ask you where those suits were filed. What lawyer represented you for those? Where did the accident happen? What insurance companies were involved? If you had a prior work-related injury, they're going to ask you about that. What doctors did you treat? Did you have any permanent injuries? Do you have the phone numbers for the doctors? Do you have the address for the doctors? What treatment were you provided? What body parts were involved? And they're going to ask you about any other injuries you had that weren't work-related, auto accident-related. It could be a slip and fall. It could be a sports injury, whatever. They're going to ask you about those, what body parts, what doctors you saw, what the doctor's address and phone number is, what the results of that was. They're going to ask you about prior surgeries, prior x-rays, prior hospital visits that you've ever had in your life. Anything that may be relevant to your medical history, they're going to ask. Once you give these answers, be advised that everything that you say at that deposition may be checked out. So anything that you said there, you can pretty much assume that the other lawyer is going to check and make sure that whatever you said at that deposition is accurate. So he's going to send for all your medical records. Once he goes through those medical records, he may find things that you failed to tell him. So it's important that you be as complete as possible, because if you're not, even though you're not trying to hide something but you just forgot it, the other lawyer is going to be able to make a trial look like that you were trying to hide something when in fact you just forgot it. Once the deposition is complete, you're advised that you have a right to read the deposition and sign it, or you can waive that right. I usually advise clients to read it and make sure the court reporter understood what you said, because if they didn't, you can write that down. In addition, in Maryland, you can make additions if you remember things after the deposition that you didn't say at the deposition. Remember, finally, that the deposition is a very important part of the case. It's important to the lawyers because it helps them find out what's going on. It's important to the clients because this is your really first chance to make an impression on the other lawyer. So please make sure that you prepare for the deposition in advance. Get all of this information in advance. In addition, other things that are important in the deposition is that you be honest. Second thing is that you answer questions in a certain way. So if the question is asked in a way where you can say yes or no, I always tell clients to say yes or no. More often than not, when a client starts going off and talking for 5 or 10 minutes after a question's been asked, more often than not, they'll give answers or information that was never going to be asked that may be helpful or harmful to the case. In addition, they may come off differently than if they had just answered yes or no, or they may basically give wrong information that would have never been asked for. So please answer yes or no if you can. If it requires an explanation, please keep your explanation as short as possible. Don't ask the other lawyer why he's asking you questions. If he doesn't have a right to ask, your lawyer will object for you. Be cooperative in the deposition. You want to come off as a cooperative person. So when they ask you something, don't get in a fight with the other lawyer. Don't get angry. Answer his question and move on. If you follow all of these instructions, then your deposition will go well and you'll be more likely to be able to settle your case and get a good settlement. If you don't follow these directions and you don't prepare for the depositions, then more likely than not, you'll be disappointed with your settlement if your case settles, or you're going to have a hard time when you go to trial. Again, my name is Marc Atas. I'm an attorney in Baltimore, Maryland. My office is located at 6 East Mulberry Street, Baltimore, Maryland, 21202. My phone number is 410-752-4878. My 800 number is 800-749-4878. My email address is matas@ataslaw.com. That's M-A-T like Tom, A-S like Sam, @ataslaw.com. Thank you.